The Western States Water Council wrote that to express their strong opposition to H.R. 1837 as a, quote, unwarranted intrusion on the rights of states to allocate and administer rights to the use of state water resources. Mr. Speaker, this bill would set a dangerous precedent of preempting state water rights, leaving other states vulnerable to this kind of federal infringement, effectively letting representatives from New York, from Michigan, from Florida, and from Texas vote on California water. And I know as a representative from Colorado, I wouldn't want the shoe to be on the other foot in having representatives from across the country deciding what we do with our water.
But this legislation throws out the ability of the people of California to decide its own water future. For those of our colleagues who represent areas outside of California and plan to support the bill because they may not impact your state, I have news for you. This is not just about California. H.R. 1837 would set a precedent that would create a domino effect, that it could happen next in Utah, Colorado, Nevada, Texas, and so forth.
Now, the opponents have just said, well, this preempts state water rights. It doesn't preempt state water rights. It specifically invokes and protects state water rights against infringement by any bureaucracy, local, state, or federal, a legitimate constitutional function of the federal government established under the 14th Amendment and made essential by the terms of the state-approved joint operating agreement of these intertwined water systems.
Now, while this bill directly affects the state of California, even though the state of California opposes the legislation, it is also opposed by representatives of the other Western water interests, the state of Montana, the state of New Mexico, the state of Oregon, the state of Wyoming, the state of Colorado, all join California in saying they don't want this bill. And why are they all saying that? Well, they're saying it because of the precedent that it will set in upsetting settled water rights in the West. Now, to address that issue, the Republicans have inserted in the bill language that says this bill does not set a precedent in upsetting all the water rights in the West as it upsets all the water rights in California.
Now let us understand that this bill has profound implications on every state, some 21 states that have contracts with the Bureau of Reclamation. This bill, should it pass and become law, is a signal to every state that you cannot count on state law allocating the water within your district. Instead, it will be Congress that will allocate the water within your state.
Mr. Speaker, it is odd, very odd, to hear the argument again in this hall that a state's right to deny basic freedoms to its citizens trumps the 14th Amendment to our Constitution. The last time we heard this argument in this hall, it involved citizens' civil rights. Now it is the citizens' water rights, but make no mistake, it is the same old song. The reason we have a 14th Amendment to our Constitution is because its framers recognized that states could become abusive of the rights of their citizens, including their property rights, including their water rights, and the federal government had a responsibility and a duty to protect them. A responsibility and a duty specifically vested in this Congress, a responsibility and a duty that we exercise in the bill that the gentleman from California would have us gut. Well, what does the Constitution actually say on the subject? It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And it grants Congress, quote, the power to enforce by appropriate legislation the provisions of this article. Now let us turn to the provisions of the bill that the gentleman objects to. It's Title IV. It directs the Interior Secretary in the operation of the Central Valley Project, a federal project, I might add, to strictly adhere to state water rights laws and priorities. It doesn't trample state water rights, it invokes and enforces them. Title IV goes on further to direct the Secretary to strictly adhere to and honor water rights and priorities that were obtained or existed pursuant to various sections of California Water Code. I repeat, it doesn't trample states' rights, it invokes them and enforces them. This sets no precedent for other states. California is the only state in the country with a coordinated operations agreement that combines a federal project, the Central Valley Project, with a state project, the State Water Project, and done so, by the way, at California's request and with California's consent. In fact, Congress has a long history of citing that coordinated operations agreement to invoke preemptive authority over this coordinated federal and state project. The Central Valley Project Improvement Act in 1992 is replete with such preemptions. Mr. Speaker, fewer Americans are working today than were working the day that this administration was sworn into office. This administration's actions caused thousands and thousands of hard-working, farm-working families to lose their jobs. This measure solves that travesty. The same administration that is blocking the thousands of jobs that the Keystone Pipeline would produce has also vowed to veto this measure. I think the American people are going to have a great deal to say about that in coming days. Ironically, the provision that the gentleman would have us remove was specifically placed in the bill because he and his colleagues objected that its original provision might cause the state government to actively undermine the rights of its senior water rights holders. Now, that was a legitimate concern. Senior water rights holders in Northern California were scared to death that they might have the state undercut their water rights, and this bill specifically addresses that concern. To address that concern, this provision was placed in the bill, and now the gentleman objects to it. The gentleman first attacked the bill because the bill lacked this protection, and now he attacks the bill because it has that protection. The gentleman knows, I hope, no, I will not. The gentleman knows, the gentleman knows.
I didn't hear from the gentleman.
The gentleman knows that I have great affection for him. But I must say he is becoming exceedingly hard to please. I yield back.
And the facts tell a whole different story. If you look at what UC Davis did, if you look at what the University of the Pacific did, UC Berkeley, all their numbers point to a loss associated with certain things. A loss of jobs associated with the drought, a loss of jobs associated with an endangered species. But these are in the hundreds or the single-digit thousands, not anywhere close to 30 or 60,000.
Just heard here that, oh no, it's not maybe X thousands of jobs that are going to be lost, it's X minus a few thousands of jobs that are going to be lost. What? Did I just hear that? I just did. You know, rarely do you see such a reckless and immoral disregard for American families, for American farmers, for American farm workers, for hard-working people.
Here we are in a country where the American people are asking, where are the jobs? The President says he's doing everything he can to help create more jobs in America. Well, here's a situation where we've got tens of thousands of farmers and those who work on those farms in the Central Valley of California being denied the use of their own land, being denied the labor to feed their own families because someone is abusing the law. This is a good bill and not a pass.
And by the way, facts are ugly little things. There was no 30,000 people that lost their job, no 60,000 people that lost their jobs. The University of California, Berkeley, University of California, Davis, and University of Pacific all say that the losses were less than 7,000.
You know, a lot has been said about our area of the state where you have 30 to 40% unemployment in some areas. It's not a Republican issue. It's not a Democrat issue. It is an American jobs issue to put people back to work. And some people say, well, those aren't the kind of jobs that we want. You know, it's a dusty, dirty way to earn a living. Yeah, it is dusty. It is dirty. I'm a farmer. And without water, you shut down not only my farm, but you shut down farms throughout the valley. You shut off our food supply. You shut off all of those jobs that desperately rely on water.
I must say, for those of us that have seen this with our own eyes, that saw the devastation in the Central Valley, we know for a fact that when the aqueduct pumps in California were slowed, when that water came to a halt because of the orders and opinions issued partly by the Obama administration, what we saw was devastation. And we saw the worst of it in 2010. Over 1 million acre-feet of water were lost. Tens of thousands of jobs were destroyed in our state. The unemployment rate, my friends, in some of these Central Valley towns reached 40%.
Thank you, Mr. Speaker. And yes, I too also toured the area, and the devastation was very severe. And I wish that some of the areas find another way to be able to find employment, because this is a chronic unemployment circle, if you will, for years, for decades. It isn't just new.
Fewer Americans are working today than were working the day that this administration was sworn into office. This administration's actions caused thousands and thousands of hard-working, farm-working families to lose their jobs. This measure solves that travesty. The same administration that is blocking the thousands of jobs that the Keystone Pipeline would produce has also vowed to veto this measure. I think the American people are going to have a great deal to say about that in coming days.
This legislation, very artfully, in a very complex series of languages and changes in law and word, takes 800,000 acre-feet away from the environment of the Delta, that would be the aquatic environment, and delivers it to the water contractors, the south of Delta water contractors.
In 1992, the Central Valley Project Improvement Act carved out 800,000 acre-feet to be dedicated to fish and wildlife purposes temporarily. In fact, during Senate debate, the floor manager of the conference report, Senator Malcolm Wallop, pointed out that 800,000 acre-feet of CVP yield is upfront water designed to deal with the requirements of the Endangered Species Act and Delta requirements while the various mitigation actions are undertaken. The various mitigation actions were to build more supply so that 800,000 acres taken from the farmers would then be returned to them. That 800,000 acre-feet came out of allocations of the Central Valley Project that were agreed to by all sides. They were incorporated in the Bay Delta Accord, which this bill restores. But somewhere along the line, the federal government began treating this allotment as a floor rather than as a ceiling. In fact, in the mid-1990s, a zealous official in the Interior Department under Bill Clinton ordered that more than 1 million acre-feet of water appropriated by the Central Valley Project be used for purposes not authorized under water rights permits issued by the state of California. That preempted state water rights laws, I might add. And I believe the gentleman from California knows him. In fact, I believe the gentleman from California is him. This bill reestablishes the 800,000 acre-foot allotment agreed to by all sides when Interior Secretary Bruce Babbitt promised that, quote, a deal is a deal. This provision redeems the promise that was broken by Mr. Babbitt's deputy, and this is the provision the gentleman would have us delete.
We are supporting sound science with H.R. 1837, and we are rejecting junk science that has long been foisted on the people of California. Junk science that the federal court has labeled the unlawful work of zealots. It is important for me to impress upon the House, the opponents of 1837 do not possess scientific high ground, as they are all but certain to allege. Their experts and the activists masquerading as experts who support them have been biased from the beginning. and have molded their work to produce the findings that best suit their radical agenda. We can say this with certainty that this agenda has not improved the fish populations. If that were true, we would not be here today. Mr. Speaker, the U.S. District Court has thrown out the biological decisions used to justify the horrible regulations that cut off water supplies to families throughout California. The court's decision was a shocking indictment of the kind of government operating in America today when it comes to our environmental laws. The U.S. District Court judge said, quote, "I've never seen anything like it," unquote. He went on to say that government scientists acted like zealots and had attempted to mislead and to deceive the court into accepting junk science. These are powerful statements by the federal court and should give anyone who believes in due process, open government, and justice a cause for concern.
Our amendment states that the Central Valley Project and the State Water Project shall be operated in a manner that meets all obligations under state and federal law, with operational constraints that are based on the best available science. More than 750 plant and animal species depend upon the Delta for their survival. Many of these then support important industries, such as fishermen, hunters, recreational industries, and farmers that promote local and state economies.
And I don't know why the Republicans have this aversion to using modern science. But I will tell you this, that this is going to be a defining vote here on the House floor. Do the Republicans actually believe in science? Do they want modern science to be used, or do they want some science from 2 decades ago to be used? The importance of using science is it doesn't depend on one man. It relies on hundreds and thousands of scientists testing each other's works. The Republican bill would ignore 18 years of work by hundreds and thousands of scientists to reach today's consensus because they want that old science in order to take care of the special interests.
I started early. We keep hearing, well, that was then and this is now. Science has changed. So should our policy. If that's the case, then the federal government's promises are worthless. They mean nothing. That was a promise agreed to by all parties. It was broken by the federal government. What they're referring to is not science. It is ideology masquerading as science. So has said the federal court. Now we have news from the Klamath that one of the scientists involved in the reports is now charging that the department subverted science for political ends. It is time that the ideological zealotry that threw thousands of families into unemployment be replaced with practical and fact-based solutions that keep our promises. It's time that we placed a higher value on human lives than on the bureaucratic dictates of the environmental left. That's what this bill does. That's what the gentleman's amendment would prevent. Finally, the gentleman would insert a requirement that the act require the best available science to move forward. Well, the gentleman knows that what he has termed best available science was literally thrown out of court, with the court saying not only was it not the best available science, it wasn't science at all. The only practical effect of the provision is to provide employment for the only growth sector left in California's economy, environmental lawsuits, intended not to win because ultimately they do lose, but rather to delay projects indefinitely and make them cost prohibitive to pursue. But I compliment the gentleman on his creativity.
If we don't do anything else here, at least we should say that we're going to use science. We're going to use the best available knowledge about science to ensure that this legislation does not invoke the law of unintended consequences.
This is scientific evidence. This shows as the bass population has increased, the smelt population has declined. And this bill rectifies this. This bill allows fishermen to fish for the non-native species. And they talk a lot about these dangerous pumps that are pumping this water, these engineering projects that allowed this valley to bloom, that have improved the environment over the time. Less than 2% of the juvenile salmon is negligible in the pumps. 65 to 90% of the juvenile salmon are being eaten by this bass.
Yield the gentleman one additional minute.
Gentleman is recognized for 1 minute.
And here we have evidence of this. You can see the bass, and I know this is a little gruesome for some folks at home, but here you have the smelt inside the bass. But yet, this government is allowing this non-native species to eat the thing that they so love, the Delta smelt.